and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about a federal court ruling that was just issued. So what this issue was is that Trump had essentially said and tried to make a ruling that persons who were here on F1, J1, or M1, non-immigrant visas, which are, F1 is for regular students, M1 is for vocational, J1 is for trainee, that once they were out of status, they would begin accruing unlawful presence days. The judge ruled that that is not to go into effect, that they will not accrue unlawful presence days once out of status, and that ruling is nationwide. Now, it's just a temporary injunction, which means that the merits of the case still need to be determined. However, let me just tell you for a moment what unlawful presence is so you understand, number one, the impact of the ruling, and number two, why Trump was trying to make it more difficult. So when someone comes in, first of all, unlawful presence is generally when you're out of status. So let's say you come in on a visitor visa, a B2. And let's say that you are supposed to leave on January 1st, but you don't leave until May 1st. So that's January to February to March, April, May. So that's 4 months. So that means you have accrued, by the time you leave, 4 months of unlawful presence. Okay, so what does that mean? Well, let's say you want to come back again. The 4 months puts it under the discretion of the officer to deny it. But what you have to concern yourself with is the 3 to 10 year bar. That's when you're not supposed to come back for either 3 years or 10 years because you're barred because you have accrued a sufficient amount of unlawful presence. Now, at the 4 months, it doesn't kick in. But let's say you overstayed 7 months. Well, from the amount of unlawful presence from 6 months to 1 year, when you leave the country, you're barred from coming back for 3 years. So that's the 3-year part of the law, the bar that keeps you from coming back. Now, let's say you overstayed a year and a half. Well, then you've overstayed more than a year, and now you're subject to the 10-year bar. So you leave and you can't come back for 10 years. Now, there's always ways of doing waivers and trying to file petitions to avoid that. But without anything else and minus anything else, you'd be subject to the 10-year bar. So the way it's been up until now, even from the beginning, is if someone came in on an F1, a J1, or an M1, they do not get on their I-94 a definite date of when their status ends. It just says D/S, which means duration of status. So if you go to school for 1 year, that's the duration of how long it'll be. If you go to school for 5 years, that's the duration. So it depends, okay? And the way that the law has been is that you could go out of status. Remember, there's a difference between being out of status and accruing unlawful presence. So, for example, with F1, the way it's been is that let's just say you finished your schooling in January and you didn't switch to any other status. You didn't go to school. You started working. So you're clearly out of status. Because there was no definitive date as to when your status would end, like with a B2, like again with the B2, it might say stamp here until January 1st. Okay, then January 2nd, you start accruing unlawful presence. But that's not the case with F1, J1, and M1. And so the way it's been is, we've been able to file all kinds of petitions. They go to the consulate. They would not be subject to the 3 to 10 year bar. They'd be able to come back and go from there. Again, part of it is because the D/S doesn't give a definitive date. And so the way it has been is only if a judge ruled they were out of status, that date of the ruling would determine when unlawful presence begins. Well, Trump tried to make it so that beginning in last August, that the amount of unlawful presence would begin with the F1, J's, and M's, essentially the moment that their situation mandated that they were out of status. Well, on one hand, there's an issue of when someone becomes out of status and what date that is and so forth. And that wasn't in the regulations. Okay. He just tried through executive order to make that, and that's what the judge stopped. So it essentially penalized much more significantly people on F, M, and J. So the ruling is a victory as it stands right now. Let's hope that when it gets to the merits hearing, that in fact it will, the judge will rule that Trump was unable and couldn't do that, and he doesn't have the authority to just change congressional law without going through the proper channels. So if you have more questions about unlawful presence and out of status, because those issues can get rather complicated, give me a call. I'll be happy to give you a free consultation, and we'll go from there. If you like the video, click thumbs up, like, and more on the coming videos. Thank you. Bye.